The Law Factor with advocate Clarence Arenas-Gandawa.
Greetings of the day. Bail was created to protect freedom, to ensure the accused returns to court, not to punish them before trial. But across Africa, bail has become a weapon, a tool of control, a silent sentence before the sentence. If you're poor, bail becomes a prison. If you're outspoken, bail becomes a warning. If you're politically inconvenient, bail becomes a muzzle. And when liberty depends on money, justice becomes a marketplace. Freedom must never be for sale. Pre-trial punishment, jail before judgment. The Constitution says you are innocent until proven guilty. But the system often behaves as if you are guilty until you can pay excessive bail amounts, endless remands, investigations still going on, police opposing bail without evidence, prosecutors using bail hearings to intimidate, courts treating bail as a privilege, not a right. This is not justice. This is detention disguised as procedure. Pre-trial detention should be the exception. It has become the norm. When the state uses bail to punish, it is no longer protecting society. It is protecting its own power. Let's look at a case study. The street vendor in Lusaka. A street vendor in Lusaka was arrested for obstruction. His crime? Refusing to pay a bribe. He was taken to court. Bail was set at an amount higher than his monthly income. He could not pay. He lost his stall, he lost his goods, he lost his income, and all before he ever saw a trial. Months later, the case was dismissed. No evidence, no witnesses, no crime. But the damage was done. He was punished not by conviction, but by poverty. This is the injustice of weaponized bail. Punishment without guilt, suffering without judgment. Judicial responsibility. Bail is a constitutional shield. Judges must remember, bail is not a generosity, bail is a right. Courts must insist on evidence-based reasons for opposing bail. Proportional bail amounts, clear timelines for investigations, alternatives to cash bail, protection of vulnerable and indigent accused persons. A judge's robe is not decoration, it is a shield, and that shield must protect the powerless from the machinery of the state. When courts fail to guard bail, they become silent partners in injustice. Let's talk Parliament. Legislating against abuse. Parliament must close the loopholes that allow bail to be misused. Laws must require strict limits on pre-trial detention, mandatory written reasons for denying bail, caps on bail amounts, automatic review of prolonged remand, penalties for officials who delay investigations, legal aid for bail applications. When Parliament is silent, the police improvise. And improvisation is where abuse thrives. A nation that respects liberty must legislate liberty. Public education. Know your rights, protect your freedom. Citizens must understand bail is a right, not a favor. Police cannot oppose bail without evidence. You cannot be detained simply because you're poor. You have the right to legal representation. You can challenge excessive bail in court. Knowledge is not noise. Knowledge is defense, and defense begins with awareness. Churches, radio stations, chiefs' councils, community meetings, these must become classrooms of constitutional rights. Eswatini in focus. Bail as a gatekeeper of power. In Eswatini, bail decisions often reflect delays in investigations, excessive remands, high bail amounts for low-income citizens, political sensitivity influencing outcomes, limited access to legal aid, courts overwhelmed by caseloads. This creates a dangerous pattern. Freedom becomes negotiable, justice becomes selective, and the Constitution becomes conditional. Eswatini must reform its bail system before pre-trial detention becomes a quiet form of political and economic punishment. Liberty must not depend on wealth, liberty must depend on law. A justice system that jails the poor and frees the powerful is not a justice system, it is a hierarchy. Bail must never be a weapon, never a threat, never a punishment. The law must ensure that every citizen, rich or poor, loud or quiet, powerful or powerless, stands equal before the scales of justice. Do not fear the accused, fear a system that punishes before it proves. Do not accept pre-trial detention as normal, challenge it. The law moves forward, you must move with it. See you next Thursday. The work continues.
Springfield Law Clinic, justice defined, rights protected. We are here to serve.